The Consumer Guarantees Act protects consumers by setting out minimum guarantees that apply to all products and services, and allows consumers to seek remedies when those guarantees are not met. The CGA applies to persons such as suppliers and manufacturers in trade who supply goods and services to consumers. Such goods and services are those that have been obtained by the way of gift, purchase, or exchange, and include take on lease, hire, or hire purchase. The purpose of the Consumer Guarantee Act is to protect and defend interests and rights for consumers. It is crucial and necessary for those businesses in the trade to know who the consumers really are. Consumers refers to individuals or entities that acquire goods or services of a kind ordinarily acquired for the purpose of living or household use. For example, Jack buys a new computer from JB Hi-Fi for his son to use. Then we could consider Jack to be a consumer. The CGA applies to him because the computer he purchased is ordinarily acquired for domestic use. Within this interpretation of a consumer in Section 2 of the CGA 1993, organizations and businesses who acquire consumer goods or services from other businesses in trade could also be considered as consumers, therefore are also entitled to protection under the Act as long as the goods and services they acquire are not resupplied in trade, consumed in the course of production or manufacture, or used to repair other goods or fixtures on land.
The CGA gives some guarantees to consumers. For the guarantees in respect for the supply of goods, the goods have to be of acceptable quality, for example, fit for all purposes for which the goods of that type are commonly supplied, acceptable in appearance and finish, free from minor defects, safe and durable. The goods must also be fit for the particular purpose for which the goods were purchased for. The goods must also comply with the description, samples, or demonstration models. The goods must also have spare parts for repairs. The manufacturer also needs to honor the express guarantees given to consumers. If it says that it will do something, it should be able to do it. Guarantees for services is that the service provider has to execute reasonable care and skill. The result of the service has to be fit for a particular purpose. The service has to be completed in a reasonable time. And finally, the price of the service has to be reasonable.
Contracting out is the means to opt out of the CGA in business-to-business transactions. Businesses that sell consumer products or services to other businesses can contract out of the Consumer Guarantees Act. This is done so by a written agreement, which outlines that a business does not have to meet the requirements of the CGA. If something goes wrong, for example, a domestic oven bought by a baker breaks down, the seller does not have to pay for the repairs or give a refund or replacement, except to the extent stated in the contract. If you provide products or services that are usually for personal or household use to other businesses, CGA requirements typically apply, but you may be able to contract out of this if, dealing with another business or person in trade, both sides agree this law won't apply. This agreement is in writing. The terms of the agreement are fair and reasonable to both parties. As mentioned, an attempt to contract out must be in written form. It doesn't matter if the document is signed or not. If the sale goes ahead, it's taken to mean that the buyer agrees to the terms of the sale. If it's only done verbally, or if contracting out is not mentioned in the agreement, the CGA applies. For example, the condition on screen is a common condition used by many businesses to contract out of the CGA during business-to-business transactions.
In the event that customers are unsatisfied with the goods or services they acquire, either due to unacceptable quality, potential cause for harm, or unsuitable fitness for a particular purpose, the retailer or supplier is entitled to fix it, replace it, or provide a refund of the purchase price. If the failure of the good or service that led the consumer to be unsatisfied is of substantial significance, the consumer is entitled to request for a replacement or refund of the purchase price. For example, if the computer that Jack bought for his son became faulty soon after he bought it, Jack can take it to JB Hi-Fi, and JB Hi-Fi can either fix the computer, replace the computer with a new one, or Jack can ask for a refund of the full purchase price. They are also entitled for consequential damages due to the failure of the goods and services provided, so far as the damage is reasonably foreseeable. The consequences for not obeying the CGA can include legal action and severe penalties. For example, attempts to contract out of the CGA between a supplier and a consumer that is not in trade can have the following penalties: $200,000 for individuals and $600,000 for companies.